स्वैप करके किसी का कहीं लगा दिया जा सकता है।
Not that simple case. I am not agreeing with your
एविडेंस में जो है कहीं भी हुजूर डेट ऑफ मैरिज नहीं है।
डेट ऑफ मैरिज तो शायद आपको भी याद होगा।
डेट ऑफ मैरिज तो हुजूर को भी याद है।
नहीं, मैरिज को नहीं याद रहेगा तो घर में भोजन बंद हो जाएगा। लेडी इज फाइलिंग दिस मेंटेनेंस केस इन ईयर 2014। आप वकील की तरह बहस कीजिए ना, क्लाइंट क्यों बनने लगते हैं? जिसका जो काम है वो कीजिए, आपका काम जो था वो आपने किया, मैं अपना काम करूं। पार्टी नेम
है हुजूर समीर मंडल वर्सेस स्टेट ऑफ बिहार एंड अदर्स।
यस,
ये है where the marriage between the parties could not be established, there is no question of grant of maintenance.
Yes,
if your lordship will बहुत and so far the judgment cited by Mr. Thakur yesterday, reported in my lord 2011 volume 1 SCC page 141. This judgment is not applicable in my case, my lord, because para 42 speaks about that, my lord, if a man and woman have been living together as husband and wife for a reasonable long period of time. In my case, my lord, no evidence has come that that the OP number 1 lived with the petitioner, my lord, for a long period, my lord. Even
that is your argument.
That is my argument.
That I have understood.
And argument supported by the evidence, my lord. During the evidence collected by the learned court below.
Evidence I will deal in my jail.
Learned court below. हुजूर आप देखा गया होगा. Even the only 2 witnesses have been examined. One the OP number.
Just in a lighter vein. आपकी शादी का कोई प्रूफ है क्या आपके पास?
मेरी शादी का प्रूफ है हुजूर, हमको डेट याद है। हमको डेट याद है।
डेट याद रहने से क्या?
हमारा अभी भी निमंत्रण कार्ड हमारे शादी का मेरे फाइल में
अभी भी छप जाएगा निमंत्रण कार्ड।
शादी आप देखा,
ये निमंत्रण कार्ड तो अभी भी छप जाएगा।
हाँ, मेरा फोटोग्राफ्स है, मेरा
इसमें जो एग्जिबिट 1 सीरीज है वो क्या है?
एक 1 सीरीज जो है
आपका अगर फोटोग्राफ है तो एग्जिबिट 1 सीरीज क्या है?
हाँ, 1 सीरीज जो है हुजूर वो देखा जाएगा, इसीलिए मेरा सबमिशन होगा हुजूर कि इसमें LCR मंगवा लिया जाए।
Why the learned family court did not look into that? Exhibit 1.
Learned
Family court accepts that exhibit 1 series has remained uncontroverted. It has not been questioned by the opposite party. It has not been questioned by your client. And in that photograph, the material exhibits which have been brought on record by the applicant wife, she is being shown in your company with your mother.
But only on
with
that
your mother. Just a minute. With your mother. She herself says that the marriage took place in the year 2002 or 2001.
2000.
Then a son was born in 2002 after 1 year of marriage. And then she was ousted in 2004. Thereafter she started living at her nair. So her name was found in the voter list.
No.
At her nair. Voter list of her nair. Her name was found. The date of birth certificate of the son, which was prepared sometime in the year 2005, that shows your name as father of the boy. The school in which he was studying, that school was giving invitation to you as his father. And then you are not questioning his paternity. Please remember. There is a finding that you are not questioning his paternity.
पर हुजूर इसीलिए हुजूर मेरा सबमिशन है कि LCR मांग लिया जाए क्योंकि पैटर्निटी पर
this court has heard the entire matter and has perused the evidences also.
पैटर्निटी
yesterday the case is fixed for judgment. I can only accommodate you to the extent that because I am going to dictate the judgment in the courtroom.
Your lordship is
So I can
aware
take
about
note of the
fact
judgments on which
even
you are relying upon.
during dictation of the judgment, my lord, some fact is brought on record.
It's
Then
not a
that's
fact that you are bringing on record. You have brought, placed before me one judgment that I will take note of.
एंड हुजूर एक चीज कंसीडर किया जाएगा जो इन्होंने क्रिमिनल केस फाइल किया आफ्टर फुल फ्लेजेड ट्रायल my lord, the trial court has held that she is not the wife, my lord.
that
There
would
is
not
no
be binding.
evidence for STL, my lord. Only 2 witnesses have been examined. That is
That would not be binding on this.
the OP number 1 as well as his uncle. No mother, no brother, no father has come forward in support of the version of the OP number 1, my lord. And only
I will only go by
then
the admitted evidences, the admitted documents which have been brought on record by your wife. And to me it appears that the learned family court has conveniently ignored those documentary evidence in one line, saying that solemnization of marriage has not been proved.
because that photograph may be आजकल तो हुजूर फोटोशॉप करके किसी का कहीं लगा दिया जा सकता है, लगा दिया जाता है अभी का जो
It's not that simple case. Here is a son
there is
who was born in 2002.
on the
He was
question
going to a school.
on the question of एक चीज हुजूर कंसीडर किया जाए, she has
अच्छा एक चीज
stated
बताइए सुनील बाबू,
जी।
ऐसी आपको कोई लेडी मिलेगी क्या कि जो बच्चा 2005 में स्कूल जा रहा है, 2002 का जिसका बर्थ है, 2005 से स्कूल जाना चाह रहा है, जब गया है, उसका फादर नेम अंकित है, आपका नाम उसमें दिया हुआ है, डेट ऑफ बर्थ सर्टिफिकेट उसका बना, वो क्यों इतना साल इंतजार करेगी मेंटेनेंस केस फाइल करने में? देखिए मेंटेनेंस केस कब फाइल हुआ है,
मेंटेनेंस केस फाइल हुआ है,
कब फाइल हुआ है, देखिए ना आप,
फाइल हुआ है 2014 में,
14 में।
हाँ 2014
तो
में।
क्या आपको लगता है कि 10 साल पहले से 10 साल से कोई डॉक्यूमेंट क्रिएट करेगा, फोर्स करेगा आपके ऊपर केस करने के लिए?
2005 में हुजूर कंप्लेंट केस फाइल हुआ, कंप्लेंट केस में जब ये समझ गई कि हमारा कंप्लेंट केस फेल होने जा रहा है, देयर आफ्टर एट द इंस्टांस ऑफ इवन द अंकल ऑफ दिस पेटिशनर, माय लॉर्ड, ऑल द documents has been manufactured.
Complaint case was the immediate reaction when she was ousted from matrimonial house. She was being ignored. You went for a second marriage. Then she filed the complaint case.
हमारा हुजूर सेकंड मैरिज तो बहुत पहले ही हो चुका है, ये तो बाद में चली आई है कि चूंकि ये इनको इंस्टॉल किया गया है।
I am not.
That's why चूंकि all these facts are the out of record.
I am not agreeing with your.
लेकिन एक चीज देखा जाएगा, एविडेंस में जो है कहीं भी हुजूर डेट ऑफ मैरिज नहीं है, डेट ऑफ तिलक नहीं है, तब तो एनी कोई भी लेडी आकर कहे कि आई एम
डेट ऑफ मैरिज तो शायद आपको भी याद होगा, डेट ऑफ तिलक तो मुश्किल होगा, हमको लगता है आपको भी याद होना। सब याद रखे हुए हैं, तो आप बड़े याददाश्त वाले लोग हैं। लेकिन जरा पूछिए झा जी बैठे हुए हैं, उनको डेट ऑफ तिलक याद है, उनको अपना
डेट ऑफ मैरिज तो हुजूर को भी याद है।
नहीं, मैरिज तो नहीं याद रहेगा तो घर में भोजन बंद हो जाएगा। ठीक है।
हाँ, और एक चीज हुजूर दिखलाना चाहेंगे, जो स्कोप है 397 का, वो 397 मैं परमिटेड टू रीड?
यस यस।
इसलिए बेहतर हो कि पैटर्निटी टेस्ट करा लिया जाए, दूध का दूध, पानी का पानी हुजूर अलग
बताइए ना, आप रिविजनल स्कोप बताइए, रिविजनल
जुरिसडिक्शन। हाई कोर्ट और एनी सेशंस जज may call for and examine the record of any proceeding before any inferior criminal court situate within its or his local jurisdiction for the purpose of satisfying itself or himself as to correctness, legality or propriety of any finding of the court below. And the same language has been used, my lord, in subsection 4 of section 19, my lord, of the Family Court Act, my lord. लगभग same and similar language has been used. Section 19(4) में.
Where is the quarrel with that? That regional jurisdiction is 397 says this. Where is the quarrel with this? Why are you going into that?
I am going to this fact, my lord, because if the LCR is called, then your lordship may peruse the entire evidences, my lord, entire exhibit, my lord, even the judgment of the learned trial court, my lord,
See,
has.
in these matters, in each and every case, we cannot go on wasting time by calling LCR. And for that reason only, that to satisfy myself, I called upon you yesterday to provide me a copy of the deposition. And you provided me that. Now I have gone through that evidence.
Because so far the question of photograph which has been raised by your lordship today,
No,
that,
it has not
that
been.
photographs may be.
It has not been raised by me. A judge never raises anything.
Sorry, my lord.
I only go through the records, and from the records, what I gathered, that I am telling you.
अब सेक्शन 19(4) भी हुजूर परमिशन हो तो हम प्लेस
आप पढ़िए ना, प्लेस कीजिए, मैं मना नहीं करता हूँ किसी को.
The High Court may of its own motion or otherwise call for and examine the records of any proceeding in which the family court situate within its jurisdiction passed an order chapter 9 of the Code of Criminal Procedure so and so for the purpose of satisfying itself as to correctness, legality or propriety of the order, not being an interlocutory order, and as to the regularity of such proceeding.
Yes.
Mandate of section 19(4) and section 309.
Mandate is not that in every case compulsorily
No,
LCR is to be called for.
May word has been.
अब तो देखिए, now we are deciding criminal appeals without paper book.
No.
आप सिचुएशन समझिए ना, एक ऐसा सिचुएशन आ गया है जहाँ पर कि हर केस में अगर LCR कॉल करने लगेंगे तो अभी तो 2016 का मैटर आ रहा है ना.
जी जी.
मालूम होगा 2026 में जो है ना वो फिर.
ये तो सिचुएशन हमारे साइड से जो ऐसा है कि अगर इस तरह का केसेज आने लगे कि एनी वुमेन केम एंड से कि दैट आई एम मैरिड विद सो एंड सो,
court is there to,
because prima facie the wife has to establish that she is legally wedded wife or not, she is wife or not, or even she lived together as husband of wife for a long period. But in the present case, my lord, in absence of all these two ingredients, my lord, because no any independent witness has been brought, has been examined, my lord, no Pandit, no Nai, no Thakur, nothing has been, only on the basis of two witnesses who is one of the...
This lady is filing this maintenance case in the year 2014. Had it been a planned one, that these documents were prepared with an intention to fetch money from you,
Of course,
by way of maintenance, then she would have filed the maintenance case long back in the year 2005 itself.
Some of the documents has been prepared in the year 2008, 2010, my lord.
How?
Even
Which document has been prepared in 2010?
In 2000, her name has been included in the voter list, my lord, by the with the.
I am not going into any disputed document. I can assure you that I will not defeat you by looking into any disputed document which are on the records. I will only refer the admitted documents, the documents which you have not challenged. And to me it appears that on the face of there being no challenge to those documents,
Even on the question
the
of
family court should not have.
even on the question of paternity, my lord, the case was pending for about 2 years, my lord. But as per my information, my lord, the applicant OP number 2 did not ready for.
That is not the finding. That is not the finding. Finding is otherwise against you.
इसीलिए
Finding is that
हैंड प्लेयर है.
Why are you folded?
LCR मांग के देख लिया जाए.
Folded hands का क्या जरूरत है सुनील बाबू? आप वकील की तरह बहस कीजिए ना, क्लाइंट क्यों बनने लगते हैं?
मेरा हुजूर सिंपल प्रेयर है कि
You have already argued the matter.
किया जाए in order to examine the
देखिए हम तो सोचा था कि जजमेंट डिक्टेट कर देंगे, लेकिन अगर आप ऐसे लटकिएगा तो हम जजमेंट रिजर्व कर लेते हैं फिर.
As you know,
There is some difficulty.
no, there is no some
Some
difficulty.
lawyers would not allow you to dictate in courtroom.
No. ऐसी बात नहीं है. I finish
Allow
my
me
argument.
to
I
allow me to
finished my
dictate.
argument, my lord, because my anxiety was to
Be
please some-
contented, be contented. You have argued, you have done your job. Let the court decide the matter
Okay.
in whatever ways it goes.
Because the judgment which has been cited by me, my lord, perhaps as per my view, my lord, that by that judgment, my lord, my case is fairly covered.
You are perfectly right. I will refer your judgment. But then I will see whether your case would be squarely covered or not.
Your lordship is right. It is your prerogative, my lord.
जिसका जो काम है वो कीजिए. आपका काम जो था वो आपने किया. मैं अपना काम करूं.
Operator.
ठीक है. Yes, you have anything to say? नहीं. लिखिए. Third land counsel for the parties, with the consent of land counsel for the petitioners, petitioner in both the revision applications, petitioner and the opposite party in both the revision applications, these two matters have been taken up for consideration together. Full stop. In criminal revision number 331 of 2017, petitioner is the husband who is aggrieved by and dissatisfied with the judgment and order dated 7/2/2017 passed by learned Principal Justice Family Court Jahanabad in maintenance case number 53 of 2014, whereby and whereunder the learned family court has partly allowed an application under section 125 CRPC referred by the opposite parties. Full stop. The learned family court has, while rejecting the request of the opposite party number 1 to allow maintenance to her, took a view that the opposite party number 2, being son of the petitioner, would be entitled for a maintenance of rupees 2,500 per month. Full stop. It is this order to pay rupees 2,500 per month to OP number 2 which has been challenged by the petitioner. Full stop. Next. The main ground taken for the challenge is that the learned family court has held that OP number 2 is an illegitimate son of the petitioner. Full stop. It is submitted that the marriage between the petitioner and the OP number 1 would not be proved, and there is a categorical finding of the learned family court in the impugned judgment that the applicant wife had failed to prove a valid marriage and or a long living relationship which were required to take a view that the OP number 1 is a legally wedded wife of the petitioner. Next. On the other hand, the opposite party number 1 and 2 have preferred criminal revision number 630 of 2017, seeking to challenge the impugned judgment whereunder the claim of maintenance of the opposite party number 1 has been rejected, and the opposite party number 2 has been allowed a maintenance of rupees 2,500 per month only, with effect from 10/7/2014. Next. The petitioners in criminal revision number 630 of 2017 has submitted that the documentary evidences laid before the learned family court go a long way to show that the petitioner number 1 is the wife of OP number 1, and from their wedlock a son who is OP number 2 was born. Full stop. It is their further contention that the learned family court from Jahanabad has rejected the claim of the applicant number 1 without appreciating the materials available on the record, keeping in view the requirements of section 125 CRPC. Full stop. It is submitted that section 125 CRPC is a piece of social legislation, and the purpose behind incorporating section 125 in the statute book is to provide a succor to the neglected women and child. Full stop. Next. This court has next कीजिए. Both the parties have relied upon some judgments of the Honorable Supreme Court. Full stop. The petitioners in the case in criminal revision number 331 of 2017 has relied upon a judgment of the Honorable Apex Court in the case of Samir Mandal versus State of Bihar, reported in 2001-3 PLJR page 80 within bracket SC. इसका citation ले लीजिएगा Supreme Court SCC. To submit that where the marriage between the parties could not be established, there would be no question of payment of maintenance. Next. Land Counsel for the opposite parties in criminal revision number 331 of 2017 has opposed this application and supported criminal revision number and supported his contentions in criminal revision number 630 of 2017 on the strength of the judgments of the Honorable Supreme Court In the case of so-and-so versus so-and-so, AIR 1952, Supreme Court, page 231, 1999, 7 SCC 675, and 2011, 1 SCC 141. Full stop. Next. This court has heard both the sides and perused the records. Full stop. In course of hearing, learned counsel for the petitioner in criminal revision number 331 of 17 has produced the copy of the deposition of the witnesses, and this court has perused the same, has gone through the same. Next. On perusal of the impugned judgment, it appears that the learned Principal Judge Family Court Jahanabad framed as many as 5 issues in this case, and even as the proceeding under section 125 CRPC is supposed to be a summary proceeding, the learned family court seems to have gone for deciding the application under section 125 CRPC, treating it as if it is a suit for declaration as to validity of the marriage between the petitioner and the opposite party number 1. Full stop. Next. In the learned family court, the specific case of the opposite party number 1 was that her marriage was solemnized with the petitioner in Asar 2000 at village Golakpur, and from the said wedlock, OP number 2 was born on 13/4/2002. Full stop. She went her sasural after her duragaman, but because of non-fulfillment of the demand of dowry, she was tortured and had been ousted from her matrimonial house on 18/10/2004. Full stop. In this connection, she had lost a complaint case number 326 of 2005. Full stop. She stated that she was living at her parents' house and was on the verge of starvation. Full stop. As regards the status of the petitioner, she submitted that he happened to be the only son of his father, he has got 10 bighas of land in village Sikandarpur and 3 bighas land in Mallahachak, Kutia at Jahanabad and 2 bighas land in Jahanabad town. Full stop. He is engaged in selling of, क्या आप बेचते हैं?
Furniture, Suman sale furniture.
Selling of furnitures.
As per the submission of the...
Selling of furnitures. And Suman sell furniture in a shop under name and the style of Shubham Sale.
Suman sale.
Suman Sale Furniture, from which he has an income of at least rupees 50,000 per month. Full stop. She had also implemented